Hi guys, there are as many as 50 states in the US, but not all are equally successful. When it comes to choosing a jurisdiction of incorporation, many companies choose Delaware. Some of the world's largest corporations are registered there, including Google, its holding company Alphabet and, of course, DuPont. About 80% of Delaware companies have operations outside the United States, such as AstraZeneca, which is headquartered in the US. So what attracted these companies to Delaware? We will attempt to answer that question below. But before we start, subscribe to our channel, give us a like and post the video on social media. Next, we're going to tell you why so many business people are starting companies in Delaware. In the corporate world, all roads lead to Delaware. Recent data shows that more than 68% of the Fortune 500 are now incorporated as companies in Delaware. Already about 1.5 million corporate entities have chosen this territory to register their location. It offers the best conditions for establishing publicly traded companies. Over the past year, about 90% of US IPO companies have chosen Delaware as their headquarters. However, this was not always the case. Up until the beginning of the 20th century, the favorite state for opening firms was New Jersey. Among them was the Delaware company DuPont. This situation prompted the Delaware legislature to entice DuPont to reincorporate where it was founded by passing laws similar to those of the Garden State. DuPont did indeed reincorporate in Delaware, and over 2 decades the state gained a reputation as a haven for corporate entities that it retains to this day. How did Delaware achieve such dominance and status in the corporate entity market? This tiny state has less than 1 million residents, which ranks it 45th in the U.S. state population rankings. Delaware's economy isn't that big either, 42nd in the country. In terms of land area, it's 49th in the U.S. Delaware's reputation as a top-notch territory for company incorporation is based on some distinctive features. Despite disagreements on a host of other issues, lawmakers are united in maintaining Delaware's preeminence as a place to incorporate. The state's business laws remain responsive to change. Administrative procedures for establishing a business are quick, and individual and corporate tax rates are low. A special court, created in the 1790s, handles exclusively corporate matters. Disclosure requirements for corporate beneficiaries in Delaware are relaxed, and some organizations do not need to disclose the identities of owners and managers at all. Since the effective date of the Corporations Act in 1899, Delaware has actively promoted itself as the best territory for incorporation. 3 forms of business prevailed in the 19th century: sole proprietorship, partnership, and corporation. Forming a corporation was the only form that gave the owners limited liability in the amount invested in the business. Against sole proprietors and partnership members, creditors could levy personal assets to repay business debts. But setting up a corporation was not easy. Incorporation required special approval from the legislature. No state had a law authorizing incorporation. The most democratic was New York's Joint Stock Company Law for manufacturing purposes of 1811. But it was valid only for manufacturing companies. It took nearly a century before New Jersey, trying to attract incorporated businesses seeking the Empire State, passed enabling corporation legislation. The law was permissive because it allowed a for-profit corporation to do many things that for-profit businesses had previously been prohibited from doing. Delaware soon passed its own corporation law. Critics have come to be horrified by the provisions of the law still in effect today. It allows for the incorporation of any legitimate business other than banking, and to operate anywhere in the world indefinitely. It was these inconsistencies that gave Delaware companies, especially after New Jersey repealed some of the corporate permitting rules. The enabling rules favorable to Delaware companies continue to evolve. There are no citizenship or residency requirements for shareholders of Delaware companies. Residents of other countries can establish a business entity here. However, it is mandatory to hire a registration agent with a physical address in Delaware to incorporate. It can be an individual or a legal entity authorized to do business in the state. A Delaware company may act as its own incorporation agent if it is physically located in Delaware. In 1991, the state enacted the first Limited Liability Company Act, which extended favorable treatment to the formation of LLCs, as did the General Corporation Law (GCL). State law also allows for a simple governance structure for a business entity. The founder of the corporation may serve as president, secretary and treasurer, as well as director and sole shareholder. This allows a small business, essentially a sole proprietorship, to enjoy the benefits of corporate status. The Delaware legislature has worked hard to ensure that its general corporation law is an island of stability. The GCL can only be amended by an overwhelming majority vote. Accordingly, changes to the GCL are less influenced by proposals from special interest groups and powerful corporations, which ensures consistency and makes the law the basis of a more level playing field for all corporations. The authorities are very responsive to the changing business environment as well as to the views of the academic and professional community. For example, in 1996, the state was the first to authorize the formation of a Series LLC at the behest of prominent Delaware attorneys. A Series LLC is a special type of LLC whose articles of organization allow the founders to become owners of assets and operations, and most importantly, divides liability into separate legal entities. A Series LLC can be compared to a subsidiary in a corporate structure. It must have a unique name, maintain separate records, and have its own bank account. Like the unique charter of a subsidiary, a Series LLC has its own operating agreement. Like a subsidiary, it may have separate management and different owners. Delaware's legal system, judges and practitioners are highly respected both domestically and internationally because of the court's quick decisions. There has been a separate special court, the Chancery Division, for cases involving commercial enterprises since 1792. An extensive body of case law spanning over 2 centuries is available to resolve disputes. Having a separate court for commercial cases means that the flow of non-commercial matters does not impede the flow of cases through the court system. The large number of companies in Delaware, along with the courts handling corporate matters, has resulted in a plethora of case law. In fact, attorneys in courts outside the territory often cite Delaware cases as precedent in their jurisdiction. Consequently, Delaware companies can take advantage of established business laws and know with greater certainty how to avoid litigation and other potential disputes. Already, the vast majority of attorneys and investors have familiarized themselves with Delaware's laws and forms. In addition, familiarity with Delaware laws and regulations allows startups and investors to reduce litigation costs and increase efficiency, ultimately closing financing faster than if the parties had the added responsibility of understanding the laws of a different state. Incorporating a company in Delaware provides tax advantages. Corporations that do not do business in the state are not subject to income tax. In addition, non-resident shareholders do not have to pay tax on stock. The state levies income and franchise taxes on Delaware companies. Corporate income is taxed at a flat rate of 8.7%. The franchise tax is calculated in 2 ways, the authorized shares method and the deemed par value of capital method. The authorized shares method is a flat fee of $175 to $250 per 10,000 shares or less, plus $85 for each additional 10,000 shares. The assumed par value of capital method is a flat fee ranging from $175 to $250 for the first $1 million of assumed capital without par value, plus an additional fee of $400 for each $1 million thereafter. Delaware companies that elect S-corporation status are exempt from income tax. Instead, owners are subject to tax. However, an S-corporation must still pay franchise tax. LLCs pay an annual tax of $300. Delaware has changed personal income tax rates, which range from 2.2% to 5.55% for incomes under $60,000. The top income tax rate is 6.60% for income of $60,000 or more. Privacy is another reason entrepreneurs choose to incorporate in Delaware. Corporation shareholders and LLC members have the ability to remain anonymous. Like the rest of the U.S. states, a company in Delaware does not have to file a list of names of beneficial owners, individuals who ultimately own, control, or benefit from the business when registering. However, the names of the directors of the Delaware company must be publicized. Their names appear in the annual report required of Delaware companies. In the past, corporations have achieved anonymity by simply not filing reports. Failure to comply resulted in a small fine, up to $100, and, under investigation, status by the state attorney general, a small price to pay for remaining incognito. Delaware law now states that corporations that fail to file a complete annual report will not receive a certificate of good standing, proof of the company's capacity in Delaware and right to do business. Each state has different laws regarding the right of shareholders to request a corporation's books and records. As far as Delaware companies are concerned, any contested shareholder request for a corporation's books or records is made within the state, which would require the shareholder to hire local counsel and litigate the case in Delaware courts. This is inconvenient and may discourage shareholders from taking steps to obtain corporate records. Despite the advantages, incorporating companies in Delaware is not right for every business. Delaware companies are not taxed if they do not do business in the state. However, you still have to pay taxes for earning income in the state. Filing fees are higher than in neighboring territories. In particular, the franchise tax can increase significantly if business is doing well and stock values increase. Registration and licensing requirements must be met, which means annual reports will need to be filed in both territories, doubling paperwork and costs. If there is no physical office for the company in Delaware, one must pay extra for a registration agent to handle legal documents and business matters. If any legal disputes arise, the owner will likely have to travel to Delaware. Cases involving Delaware companies are very rarely handled out of state. Guys, if you enjoyed our video but haven't subscribed to us yet, subscribe now and post the video on social media. There will be more to come in future episodes. See you soon. Bye.